sa SALN kung yun po ang kanilang pinupunto. Pero on the other hand, the prosecution is arguing na the moment you made payment, the moment na ikaw na nga po ang may-ari niyan at napirmahan yung deed of sale, ay dapat pinakita mo na yan sa iyong SALN. So ito yung mga issues na kailangan na pagdebatehan, kailangan i-interpret ng Senate sitting as an impeachment court. Meron pong pinakita itong testigong ito na isang master list na mukhang print out ng listahan po ng mga miyembro nitong condominium corporation na ito para po ipakita ang date kung kailan po aktual na tinanggap ng buyer yung unit na binili galing po sa developer. So ito po ay ebidensya ng actual possession or actual na paglipat ng control nitong unit na ito dun sa mismong nakabili. So possession versus ownership versus itong date of the actual sale, ito po ay mga key legal terms na kailangan pong pagdesisyonan. Pwede po kasing mahalo-halo yung interpretasyon nito, yung date of sale, date of actual transfer of ownership, and date of actual possession. Yan po ang mga dapat himayin ng mabuti ng mga Senate judges.
Your Honor, I'd like to manifest that I compared the originals with the documents presented yesterday, and they are faithful reproductions, Your Honor.
They're identical.
Yes, Your Honor.
All right.
Your Honor, we still have no cross-examination questions. We'd just like to request the marking of one of the exhibits as our own exhibit. This would be Exhibit 196 for the defense, which is the personal letter of Christina Corona. We'd like to mark it, Your Honor, as our own exhibit, which would be Exhibit 11Cs, Your Honor.
Mark it accordingly for the prosecution. Any other question, Mr. Counsel?
Just one more manifestation, Your Honor. We'd like to cause the sub-marking of two phrases in this letter. One is in the penultimate paragraph of the letter. It says, I have not earned any income from this investment, as our Exhibit 11C-1. And in the last paragraph, I am losing money from this investment, as our 11C-2, Your Honor.
Mark it accordingly.
With that, Your Honor, I have no further questions.
Okay.
Mr. President, may I also adopt the sub-markings for the defense as 196A and 196B?
All right.
Thank you.
Mark the sub-marking of the prosecution as stated by the defense as for purposes of identification as their exhibits.
Your Honor. Your Honor.
Any other question?
Before the witness is discharged, we'd just like to manifest that Senator Osmeña was requesting yesterday for how the payment was made on this particular unit. We'd like to manifest, Your Honor, that we filed a 3-page compliance detailing the details of the payment, Your Honor.
Who made the
It was requested by Senator Osmeña.
the prosecution?
Yes, Your Honor.
Okay, we're a bit surprised, Your Honor, but I think we have a witness who will testify to the payment, the purchase, circumstances of the purchase, Your Honor.
So what's the pleasure of the prosecution?
Just manifesting for the record that we complied with the request, Your
All
Honor.
right. The gentleman from Cebu?
Thank you, Mr. President. Actually, The documents had been submitted a couple of weeks ago, and we would like to ask the prosecution just to clarify the difference between the contract to sell, which is dated January 20, 2004, and the Annex C, which covers the purchase price and manner of payment, which are dated January 29, 2003, or a year earlier, and shows a schedule of payment, schedule of payments to be 25,000 pesos on January 29, 2003, down payment of 543,181.82 pesos on March 28, 2003. Then the installment schedule covers first installment 1,113,033 pesos and 18 centavos on April 28, 2003. The second payment being 1,728,270 pesos and 23 centavos on October 10, 2003, and the last payment amounting to 179,446 pesos and 59 centavos, and it is marked here upon advice. So the total matches the price for the condominium, which is 3,588,931 pesos and 82 centavos. I still can't get the dates right, because while the manner of payment schedule in Annex C shows that the second payment was already, the bulk of the payments had already been made as of October 10, 2003. The contract to sell is dated January 20, 2004.
In other words, the property was fully paid in 2003.
Just about, Mr. President, based on Annex C.
If I may, Your Honor, answer, because I was the one who presented the witness from Columns,
Yes.
Ms. Neresa Josef. Actually, Your Honor, what happened was initially Mrs. Corona bought a studio unit, Your Honor, in 2003. And then she applied for an upgrade of the unit to a one-bedroom unit, Your Honor. And so when it was finalized, the upgrade, it was already, I understand, in 2000, when the contract to sell was already executed, Your Honor, in March of 2004. So she started paying the studio unit, Your Honor, in 2003. And in January 2004, the contract to sell was executed.
Your Honor, while I appreciate, with the permission of kind counsel, while I appreciate the efforts to assist the court, I think perhaps that reference should be made to the record of the testimony of Ms. Joseph, was that? Perhaps that might give us a more accurate account of what was said in court, Your Honor.
Was your statement into the record covered by the answers of the witness you presented?
No, Your Honor, we did not delve into that matter already during her presentation, Your Honor.
Anyway, you take note of that.
The contract to sell, which was submitted, is dated January 20, 2004. And now you're talking about another contract to sell that was signed on March 2004.
No, Your Honor, I correct myself, Your Honor. It is this January 2004. Only one, the same, Your Honor. Only one contract to sell dated January 20, 2004.
But this is the penthouse unit that they eventually upgraded to.
Not penthouse, Your Honor. I think this is only one-bedroom unit with parking lot, Your Honor.
What was the number of the unit? Just remind
31B, Your Honor.
31, D as in David?
Is in boy, Your Honor.
B as in boy.
Yes, Your Honor.
One bedroom. Now, would the price be the same?
It was not, Your Honor. Per my interview with the witness before, there was the purchase price is not
I'm
the same.
sorry,
It
Your
was an
Honor.
upgrade.
I'm sorry, but
Excuse me, please do not interrupt when a judge is asking questions. Yes, please continue.
So, the price of the studio unit, Your Honor, is lesser than the price
Just
for
give us the price of the studio unit. Give us the price of the studio unit. Is that 3,588,000?
No, Your Honor. It is less than that. I don't have the exact amount, Your Honor.
Would you get us that information, please?
Yes, Your Honor. I
Now,
will,
the
Your
price of the one-bedroom, Unit 31B, is 3,588,000.
Honor. Yes, Your Honor. We confirm that.
But that seems to correspond exactly with Annex C. So, was the 3,588,000 fully paid when the contract to sell was signed?
When the contract to sell was signed, it was not yet fully paid, Your Honor, because payments were subsequently made, and our official receipts that were testified to and marked into evidence would show that full payment was made only sometime in 2004, Your Honor.
In 2004.
March 2004, Your Honor.
So the 3,588,931 pesos and 82 centavos was fully paid in 2004.
Yes, Your Honor.
And, well, it never appeared on the asset side of Justice Corona, the respondent.
Yes, Your Honor. It never appeared for the payments of 2003. There was no entry as to the payments that were made, as well as to the payments that were made in 2004. Your Honor.
In 2005, did the cash payment of 3.5 million appear?
No, Your Honor.
In a sal of 2006, did the 3.5 million pesos appear?
Not also, Your Honor.
In 2007, did the 3.5 million appear?
No, Your Honor.
In 2008, did the 3.5 million appear?
No, Your Honor.
In 2009,
No, Your Honor.
so it finally appeared in 2010.
Yes, Your Honor.
Now, in double entry accounting, asset equals liabilities plus net worth. In fact, the Constitution is really based on the principles of double entry accounting. So therefore, if you take something out of your asset side, you have to replace it with another asset or with a liability.
Yes.
Now,
that's
in
correct.
this particular case, how did the respondent book an asset in the amount of 3.5 million? Is there anywhere in his sal that reflected that?
Based on the evidence that we have presented, Your Honor, for the SAL-N for the years 2003 to 2009, there were no entries made by the respondent, Your Honor.
And lo and behold, it appears in 2010.
Yes, Your Honor. And our position is that, Your Honor, even under accounting rules, an entry should have been made when payments were made, and the entry should have been an investment in real property. Or it may be even an other asset, Your Honor, but no entries were made during the
Or
years.
if there was an objection or a question, maybe an accounts receivable from Ayala Land